Hello, and welcome to All Things Chemical, a podcast produced by Bergeson and Campbell, a Washington, D.C. law firm focusing on chemical law, business, and litigation matters. I'm Lynn Bergeson. On June 25, 2025, Bergeson and Campbell, along with the Environmental Law Institute and the George Washington University Milken Institute of Public Health, sponsored an all-day virtual conference titled TSCA Reform 9 Years Later. The conference was hugely successful, and almost 1,000 people registered for it. The quality of the discussion, the caliber of the participants, and the timeliness of the content motivated us to repurpose the substantive sessions to enable our podcast audience to listen to the sessions in this venue. The topic of this podcast is the panel discussion on EPA's risk evaluation process under Lautenberg. The panel discussed various aspects of EPA's risk evaluation of chemical substances under TSCA Section 6. Importantly, the panel touches upon crucially important issues including EPA's reconsideration of the risk framework rule and the legal challenge to it that is now underway, EPA's pivot away from the whole chemical approach, the incorporation of cumulative risk assessment practices and approaches, and much, much more. Now, here is the panel discussion on the TSCA risk evaluation process from TSCA Reform 9 years later.
Welcome, everyone. If you are just now joining us, we are getting started with panel 2, which is on risk evaluation. And our moderator for this panel is Mark Duvall, who is on the TSCA Programs Steering Committee. We're so grateful to have him on board. And Mark is a principal at Beverage and Diamond, where he has over 2 decades of experience working in-house at large chemical companies. His focus is product regulation at the federal, state, and international levels across a wide range of programs in occupational safety and health. Mark co-leads the firm's chemicals group. His experience under TSCA includes enforcement actions, counseling, rulemaking, advocacy, and legislative actions. Since the enactment of the TSCA amendments in 2016, he has been heavily involved in advocacy, compliance activity, and litigation arising from EPA's implementation of these amendments. So over to you, Mark, and thank you so much.
Thanks very much, Madison, and thanks to the panel for joining. Let me quickly introduce you all. There's more detailed information about each of these distinguished folks in your materials. But Rashmi, Dr. Rashmi Joglekar is the Associate Director of Science and Policy at the University of California at San Francisco, where she leads the Science Policy and Engagement Team at the Program on Reproductive Health and the Environment. Andrew Meyer is a principal at Integral Consulting, where he works on toxicology, health, and ecological sciences. He is also chair of the American Industrial Hygiene Association, TSCA Advisory Group, and other groups. Tosh Sagar is a senior attorney at Earth Justice. He is currently counsel for 2 of the litigants in the DC Circuit litigation involving the TSCA framework rule. And Karen Schmidt is a partner at Squire Patton Boggs, where she works in the public policy practice after spending nearly 25 years at the American Chemistry Council. And I'm delighted to have you all here. I am amused that the previous panel on risk management could not restrain themselves. They spent half their time talking about risk evaluation issues, because the risk evaluation issues are so interesting and they drive the results into risk management. So I'd like to get us started talking about risk evaluation in a more direct way. We're starting with the statute. So TSCA Section 6b4 provides that the administrator shall conduct risk evaluations to determine whether a chemical substance presents an unreasonable risk of injury to health or the environment without consideration of costs or other non-risk factors, including an unreasonable risk to a potentially exposed or susceptible subpopulation identified as relevant to the risk evaluation by the administrator under the conditions of use. So that provision also directed EPA to adopt a rule to govern the process for risk evaluations, known as the Risk Evaluation Framework Rule. First, Trump EPA adopted a framework rule. The Biden EPA revised that framework rule. And the second Trump EPA has announced that it plans to revise the revised rule. That announcement came in the context of litigation before the DC Circuit challenging the Biden administration's revisions. Since this is complicated enough, Tosh, can you get us oriented as to where we are and how we got here on this risk evaluation framework rule?
I think that was a pretty good summation of sort of the procedural history. There have sort of been 2 or 3 major issues that I think have been in flux since TSCA was amended in 2016 and the directive to put out a risk evaluation framework rule has started to be implemented. And so you saw the first version of this rule under the Obama administration in the proposed rule phase at the very end, I think January of 2017, just days before the transition or inauguration, I should say. And I think there were sort of 2 key issues that I think were already touched on in the prior panel. Sort of one, whether EPA is required to look at all conditions of use or whether there's a discretionary authority to exclude them at the outset of an evaluation. 2, whether or not EPA is required to make a single determination for the chemical as to whether the chemical presents unreasonable risk or whether multiple determinations for each condition of use. And then sort of there's a third issue around what do you do about PPE? Do you take it into account when estimating risk and making unreasonable risk determinations? And those views or interpretations have flipped. Sort of, I think the initial Obama rule, at least as to the first 2 issues, sort of said we're going to look at all conditions of use. We're going to make single determinations for the chemical. When the rule was finalized by EPA in, I think, June or July of 2017 by the Trump administration, it flipped on those issues. Subsequently, it flipped back under the Biden administration. We challenged the first, we being a coalition of environmental and public health and community groups, challenged the first by Trump-era rule, partial success on the merits of some of the issues, and some findings of lack of jurisdiction on some of the others. The Biden administration came in, I think adopted what we view as the correct reading of the statute, reaffirmed what the Obama administration had said. That got challenged by various industry groups and companies, including ACC and Olin. And that's the litigation that's pending in the DC Circuit, and for which the case is currently being held in abeyance while this new reconsideration process goes through. So, yeah.
Okay.
I feel I just said what you said, but in a longer format.
Well, and thank you for doing that. So let's start unpacking some of these issues. I call it sort of the marquee issue that's gotten, I think, the most discussion is the whole chemical issue. The statute says determine whether a chemical presents an unreasonable risk, but under its conditions of use. And the Biden EPA said that among the 5 chemicals that are out there in final rules, and in a number of the risk evaluations that haven't resulted in final rules yet, or even proposed rules, the chemical presents an unreasonable risk, but the following conditions of use contribute significantly to that determination, but some others don't. The original Trump administration made condition of use by condition of use determinations. Those that were findings that they did not present an unreasonable risk were immediately appealable, and they were appealed. My question to the group starts off with, why do we care? If the risk evaluation identifies some conditions of use as contributing and others as not contributing, how is that different from saying that the chemical as a whole presents an unreasonable risk versus particular conditions of use presenting an unreasonable risk? Karen, do you want to start us off with that one?
Sure. So first of all, one of the questions is when you say we, Mark, who do we mean by we, right? So stakeholders have different reasons to care, but they should all care. One reason to care is that if there is a final determination of no unreasonable risk that is adjacent to that risk evaluation itself, that completes the process, right? Final agency action. So you're done. So in terms of thinking about managing this process flow from beginning to end, right? Prioritization through risk assessment or risk evaluation to ultimately risk management. What that does is it winnows the field. That provides a very helpful tool to EPA to reach final conclusions and take them off the table and move on to regulating areas where there is unreasonable risk presented. So it's a very powerful administrative tool for the agency to manage the process from beginning to end. So that's one reason to care. But another reason is exactly what you started this discussion with, Mark, which is this is a process. Risk evaluation issues bleed into risk management. So everything that happens in scoping, everything that happens in the risk evaluation, and ultimately whatever those determinations are, use by use, is the feeder or the setup for EPA to then take risk management action use by use. So there's a really compelling argument that the entire process from prioritization to the very bitter end needs to be laser focused on specific conditions of use. That informs the review, that helps EPA manage the entire process, and it helps set up risk management at the end. So other reasons why this is helpful. Use by use determinations. Again, if there are use by use determinations that there's either no unreasonable risk presented or less risk presented, it helps EPA pre-identify whether there's risk management actions that need to be taken. It can then calibrate the specific risk management actions against the condition of use or against the risk. And it saves the agency resources. It helps them understand, are they ultimately going to need to do an alternatives assessment? How does that tie to the specific condition of use? And how do they do cost benefit review, again, when they get to the risk management step, or any other cost sort of look that they want to do for cost efficiency? How does that set that up? So when EPA conducts whole chemical reviews, it casts a shadow of ambiguity over all of this. It's unclear what's on the table, what's off the table, and how that's going to feed into risk management. So the risk evaluation and the risk management are indeed inextricably linked. And I think we need to consider as a policy matter how this process works from beginning to end for the greatest speed, throughput, efficiency, and then ultimately appropriate risk management actions where unreasonable risk remains. So those are some initial thoughts, and I'm sure the rest of the panel has plenty of thoughts on this as well.
Rashmi, we heard in the previous panel that condition of use by condition of use determinations run the risk of underestimating risks for particular conditions of use due to weak data sets. What's your thought about this whole chemical question?
Yeah, so, the more that you slice and dice these evaluations, the more that you're going to be underestimating the true risk cup, if you will. As John mentioned, people are exposed to multiple exposure pathways, multiple routes of exposure to a single chemical. Slicing and dicing into conditions of use doesn't accurately account for that. You need to aggregate exposures, you need to aggregate across conditions of use to kind of get the full picture of how people are experiencing risk to chemicals.
Other views on whole chemical before we move on to other hot topics?
Yeah.
So I would just add, Rashmi, that the statute does not contemplate being able to address, right, the exclusion categories, pesticides, FDA regulated materials. So you're inherently never going to be able to get to all those exposures, and that's baked in already.
So just something to consider in terms of how EPA is going to be able to go about its business. There will be, at various points in the future, there will be exposures where the dominant exposure is from food, for example. And EPA is not going to be able to consider that under TSCA.
So I might let Tosh speak to kind of the legal backing of this, but we do feel, and we do in our interpretation of the law, feel that there is an obligation for EPA to consider those kind of traditionally non-TSCA exposures as background exposure sources. These, when you ignore these sources of exposures, again, you're not adequately evaluating the risk posed by a single chemical, even by a single condition of use. A prime example is phthalates. One of the primary sources of exposure to phthalates is through dietary routes. When those exposures are not considered in the full picture, when making a risk determination, you're going to vastly underestimate risk to human health.
Josh, do you want to jump in?
Yeah, I think that, I think there's a lot of sort of differences in perspectives here. I'd like to hone in on one in particular. When you said, why do we care? I think Karen noted that in sort of the industry view, a finding that a particular condition of use does not present unreasonable risk takes it off the table for risk management. And I think that is sort of the crux of industry's position. I think Karen stated well here. I think it's reflected in their briefs across 2 rounds of briefing now. And I think that's the crux of the problem, right? Because in the statute, there's a mandate to protect against unreasonable risks that arise from any combination of conditions of use. But if you slice and dice into these individualized determinations and you find that particular conditions of use don't present unreasonable risk because the narrow exposure from that particular condition of use is too small, but if you were to look at it in combination with other conditions of use, aggregate the exposures, aggregate the risk, where it presents unreasonable risk, you might have to regulate. And that's kind of what Congress wanted, right? It wanted to look comprehensively across the life cycle of the chemical. And this use by use approach would foreclose that. I've never seen in any industry brief or any industry comment how they explain how that would be possible if you go use by use to look at combinations of activities. And I think that's because there is no answer. It's a gerrymandered approach to get to a result where you slice and dice things, you take them off the board, you take them off the table, and then there's no way to regulate them. So I think that's one like pretty clear problem. I think just a secondary problem perhaps is like, these conditions of use are useful analytical tools for sure, but like the goal of TSCA is to eliminate unreasonable risk. And so there are examples where EPA has, analyzed one condition of use, found that it's not particularly risky, but nonetheless needs to regulate it. The clearest practical example I could give is NMP, where you had it, the product is used both on the commercial and consumer side, I think in like kind of like maybe solvents or paints or those kinds of things. And EPA found unreasonable risk to commercial users, but not to consumer users, right? But and so what do you do there? Because there's the possibility of sort of transfer across those markets if you regulate just the commercial side. Commercial users might wind up going and purchasing off the consumer side. There's no like neat separation. So they instituted some regulations on the consumer side as well. So you didn't have bleed through across these 2 conditions of use, which are seemingly distinct, but in reality, it's sort of like, it's an open market. You can go across either side, right? And again, industry's view would prohibit that, right? Like the consumer use, EPA would have said under a use by use approach does not present unreasonable risk. I'm not sure how they can square the circle and allow for regulation there. So, I think it's pretty fundamentally at odds with the text of the statute, the obligation to decide whether a chemical presents unreasonable risk rather than individual uses. But I think it also doesn't make sense as a policy matter, just from some of the examples that we've given.
And Mark, maybe I could just add one comment.
My insightful conclusion of this is that there's a difference of opinion.
on this issue. So why don't we move on to
Well,
another one now that
Mark, can you
solved that one?
Mark, can you hear me?
Yes.
Yep. Let me just add one thing, because to me as a practitioner, I'm an occupational toxicologist and industrial hygienist. So as a practitioner, what feels to me as in wading through this, working in plants and wading through this, is there seems to be a misalignment right now between the level of effort when you do risk by COU and OES by OES detailed risk evaluation. That's a lot of energy and effort. But then that doesn't tie to. But then you say, okay, but if any of them are problematic, we're going to just lump them all together in risk management. Then there's a lot of extraordinary effort put into it. And the way I kind of tell myself this is, in reality, I'm feeling like a lot of the risk evaluation work that I'm doing is actually risk management precursor work. It's work that's going to help inform risk management. So I think really it's just an alignment issue of EPA or under TSCA decide what risk evaluation is for. And if it's for detailed understanding of each potential use, then manage to those. If it's for getting a broad sense if there's risks, then that can be done in a much more efficient manner and move quickly to risk management, which can be done in more detail. So I think that would be a better alignment than where we are right now.
Andy, doesn't the prioritization process already contemplate kind of doing that big look, that high level screening?
Well, and I think we'll talk about that too, because I know there's issues with that. I think it can, and I know there's been a lot of discussion with EPA and all the different stakeholders about how do we all work together to come up with a kind of a agreed upon, harmonized, tiered screening risk assessment approach that handles first cut at the prioritization and scoping stage, handles the second cut perhaps at the risk evaluation stage, so that we can get onto the risk management. Because at the end of the day, right, it's the risk management, to all uses that is going to actually protect people. So it feels like we could maybe get to that quicker, but that doesn't mean all the just work we're doing in risk evaluation isn't helpful in the risk management phase. Because I can tell you, in collecting data for test orders, for example, we're collecting a lot of data that we know is really geared to answering risk management questions, not risk evaluation questions.
And frankly, the whole regime of risk evaluation, risk assessment has evolved to the point where it makes sense for risk management to be separate, the risk managers to be separate from the risk assessors. But the questions being addressed by the risk assessors should be useful to the risk managers. So it makes sense that the risk evaluations are being done with the idea that somebody else is going to be making risk management decisions. Let's move on to another much discussed issue, which is call it the PPE issue, whether PPE usage is considered during the risk evaluation or afterwards during the risk management stage. The Biden administration chose that approach. The first Trump administration considered PPE usage and engineering control usage during the risk evaluation stage. Again, why do we care? Andrew, do you want to comment on that?
Yeah, that's initial thoughts. Again, kind of being a practicing industrial hygienist. I mean, the traditional, kind of as a purist risk assessor versus risk manager, we did typically, exclude PPE and other non-inherent controls as a separate piece of this process. So risk assessment is separate from those, not including them, because we knew that would be part of our control regime. We'd be building it in if there was a risk after considering inherent controls like the process, nature of the process design itself. So that is sort of a traditional approach, and I know there's been a good argument for it. And I can also see and sympathize and see the problem of including PPE at the risk evaluation stage. Obviously, is the concern that we're going to be missing poor performers. I'll say, groups who don't have robust or mature industrial hygiene programs. So therefore, there's going to be people who we may not do risk management where it's needed because we're going to be missing some of those facilities. And that again, I think anybody who's been an industrial hygienist knows there's plenty of places like that. But on the other hand, if we exclude the PPE consideration, then obviously we're going to probably be including certain COUs or OESs, at least some predominant majorities of the workforce in certain COUs and OESs that really have no actual unreasonable risk because they do have these. I kind of like EPA's approach to kind of showing it both ways, because that way you get some information, and that's been I think been helpful. But at the end of the day, I think the real concern is we need basically to have all workplaces have a reasonable, robust industrial hygiene program. And that seems that we get more bang for our buck in protecting workers if we focused on how do we get that to happen. And it seems to me that a lot more attention on basically whether it's through OSHA, EPA, or other, I'm not the policy expert, but basically what we really need is good general duty clause enforcement and good baseline industrial hygiene programs. And I can tell you for the AIHA task force, part of our effort is around trying to make sure that we can come up with principles of good practice for industrial hygiene and get penetrance of that at every workplace. So I think if we need to put a lot of energy into making sure we do have a baseline occupational hygiene set, that then we can have some confidence that most workplaces really would be protected. We're not there yet, but I feel like that's where our energy should be.
So, Rashmi, it strikes me that one way you could characterize this is sort of central tendency exposures versus high-end exposures. How do you think the issue of PPE usage should be considered in risk evaluations?
Yeah, so from a scientific perspective, it's absolutely critical that you consider the full range of exposures that people could be experiencing, in this case, in the workplace. And, that high end of exposures in this case should absolutely always consider when people are not wearing adequate PPE or no PPE at all. When you look at the hierarchy of controls, which we consider best practices, the best measure to eliminating risk to workers is eliminating the hazard, not adding PPE. So it's critical that we understand what these exposures are when people don't have adequate PPE or no PPE at all. As Andrew mentioned, there are these kind of inconsistencies across the workplace in proper PPE implementation. So why should our risk evaluations not reflect that? And again, coming back to this central tendency in high-end exposures, we have to characterize that full range of exposures in order to get again, like full spectrum of risk that people are experiencing across the population. And that high-end exposure must always include folks who are not wearing adequate PPE.
So Karen, thinking about it from a risk determination standpoint, is it reasonable to say that workers who are using PPE and employers who are using engineering controls still face an unreasonable risk if those controls and PPE are sufficient to bring exposure levels down below an acceptable level?
So one of the things to bear in mind in the risk evaluation is that there is a focus on conditions of use. So what's actually occurring in the workplace. And EPA has to consider reasonably available information. So at the end of the day, if industry or sectors can demonstrate that there are particular SOPs in place, standard operating procedures, engineering controls, PPE being used, they've done their job, right? So EPA can then consider actual real life exposure information, taking into account the exposure reduction, right? The actual exposure after that. So that's a sound and solid approach. From a determination standpoint, again, you could certainly have scenarios where some, I'll just say worker segments, are very well controlled. That use by use approach we talked about before helps the agency isolate circumstances where perhaps there is a job or a task or a segment that is experiencing higher exposures, or where there's a demonstration that PPE and controls are routinely not being used instead of, isolated one-offs. So again, that process helps get to a determination where there's much better clarity about where EPA needs to take risk management action. And risk management action should not reflect what current practices are already in place, because that's creating a duplicative regulatory structure at risk management. So I do think it's important, Mark, to think about the full process flow from beginning to end, and opportunities to allow the agency to really focus its time and resources in areas where there is unreasonable risk being presented. The process flow also is designed to be quick, right? These risk evaluations are supposed to be 3 to 3.5 years, leaving EPA only 1 to 2 years to take risk management action. So a lot of the analytics need to be done in the risk evaluation step and at that risk determination step to be able to hit those deadlines.
Tasha, do you have any views on this topic? I suspect you do.
Yeah, thanks. So I think Andy maybe said it best. I think he said as a purist, the right way to do the science is to not take PPE into account in risk determinations. And I think that reflects what the statute requires, right? The statute has a best available science mandate. The best available science going on for several decades in the occupational exposure realm is that PPE is like not an input into risk determination, but instead into risk management. And that's what the statute reflects. And I think he highlighted a lot of problems that we know that PPE is not universally used, even when provided. There are all sorts of problems with just assuming that with assuming PPE usage at the risk evaluation stage. I think the concerns about duplicativeness, at least so far, to me, don't ring true. My colleague Randy Rabinowitz, who represents the unions, made a point to me. I think it might have been about methylene chloride, or maybe about most of the chemicals that have gone through risk management so far, which is that OSHA standards are not only super outdated, like there's like an order of magnitude difference between the level of occupational exposure OSHA thought to regulate to and those EPA thought were posing unreasonable risk. And so even if you were to assume sort of like the kind of PPE usage, and particularly this is all about respirators so far, if you were to assume that, even assume that, it still really is not meaningful. Like EPA would still have to take some sort of risk management regular steps to get exposures down to the right level. And I'll just note, like, that coordination, that idea of duplicativeness across statutes, whether it's EPA regulating under TSCA versus existing OSHA requirements, or EPA regulating under TSCA versus EPA's own authorities under the Clean Air Act and or the Clean Water Act or any other EPA authority. Those are all addressed in Section 9, and those are all really about post-risk evaluation, post-risk determination, risk management steps. Like that's where that coordination should happen. That's where you should take a look at those other regulations and see whether there's a need to harmonize. That's our view on that.
So turning to another issue under the risk evaluation framework rule, the scope of risk evaluations. I think Karen raised an important point about, there's a statutory deadline, 3 to 3.5 years. And so far, no administration has been able to meet those deadlines. And the deadlines presumably reflect some congressional understanding of how long and how much resources EPA should throw at an individual risk evaluation before saying we've done enough, let's move on. Which brings up the topic of the scope of the risk evaluation, the idea of whether, as the Biden administration rule says, EPA will look at all conditions of use, but will look at some of them on more intensely than others. Versus an EPA, Trump EPA, at least in the first term approach of saying we're going to at least have the discretion to look at some conditions of use and yet exclude other conditions of use. Rashmi, I know you have some views on this. Can you start us off?
Yeah, so it's critical that all conditions of use that are reasonably foreseeable are included in the risk evaluation stage. And I might actually kick it to Tosh, who has kind of a more in-depth response to this. But sorry.
No,
But
do you want to kick it to me or do you want to keep going?
I'll kick it to you.
Okay. Yeah, I think these should be comprehensive, right? Congress pretty clearly delineated what the scope of the evaluation should be. It should be conditions of use, a term it defined to comprehensively cover the entire life cycle of a chemical. It's from the initial manufacture to the ultimate disposal. There are express carve-outs where Congress wanted to carve things out. Karen mentioned some of them earlier along the lines of pesticides or maybe things in food. So Congress knew what it was doing when it defined conditions of use comprehensively, and it's flatly contrary to the statute to, I think, exclude them at the outset. I think.
Let me just interrupt you for a second, Rush.
Yeah.
Tosh. The statute, I think, can be read both ways. So the relevant provision that says the administrator shall publish the scope of the risk evaluation to be conducted, including the hazards, exposures, conditions of use, and potential exposure to susceptible subpopulations the administrator expects to consider. So expects to consider suggests perhaps it has discretion to pick and choose, but you take a different view of that language.
Yeah. So I'll direct people to our briefs if they want to read them, but I'll try and be as succinct as possible. So, right, this is at the scoping stage. You're 6 months in. Yeah, you have an expectation of what you're going to consider. You might gain new information that shows that there are conditions of use EPA didn't know about. That EPA might gain information to show that something they thought was a condition of use is discontinued such that it will no longer qualifies. That's happened repeatedly. Again, that's in our briefs. I think the Ninth Circuit in the original Safer Chemicals decision rejected this idea that expects to consider as a grant of discretion. I could go on and on. There are lots of rebuttals. I think maybe the clearest example of why this is problematic is 1,4-dioxane, where at the scoping stage, 6 months into the process, EPA excluded a host of conditions of use, primarily related to byproducts, where 1,4-dioxane is a byproduct of the manufacture of a whole other class of chemicals, I think ethoxylated chemicals. And ultimately, the Biden administration reanalyzed those excluded conditions of use and found they posed unreasonable risk. So, like, if the core goal is to look at the life cycle of a chemical and find what activities pose unreasonable risk, this sort of pick and choose approach, I think, inherently leads to a significant likelihood that you're going to overlook unreasonable risks. That happened for 1,4-dioxane. I think it happened for methylene chloride, where fence line air exposures were excluded, and subsequent analysis showed significant cancer risk, and it'll continue to happen as long as it's allowed. I do want to respond to like this policy point that I think keeps coming up and up again, which is about timing, which is there were 3.5 years to do these risk evaluations at most. And so like necessarily EPA keeps missing the deadlines. So necessarily EPA should be given discretion. So first, there was email when Congress was interacting with EPA. They were seeking technical assistance from EPA congressional staff, congressional liaison staff, and there's emails back and forth between the agency where the agency said to Congress, 3.5 years is enough time to do comprehensive risk evaluations. So that was EPA's representation to Congress, and that's how Congress chose to legislate based on those representations. I think the fact that EPA is missing deadlines can be chalked up to a couple things. There are little to no new resources for the existing chemicals program. That's something that Dr. Friedhoff, I think, banged the drum about for many years. It's a brand new program. You would expect implementation hurdles, I think, is a second. Even if they had gotten new resources, could take time. And the third is an area that I also practice in, which is the Clean Air Act. And there, I don't think EPA has once, and the Clean Air Act has been 1990. So the amendments to the Clean Air Act set up the hazardous air pollution program. I don't think there's a single rule. There are 8-year deadlines to complete rulemakings. I don't think there's a single rule that EPA has completed on time. I don't think that tells you anything about whether EPA is the scope of the analysis is correct. I think it tells you a lot about whether EPA chooses to put resources to complete things on deadline, as opposed to, doing a lot of discretionary stuff that EPA does. So I think those are better explanations for how and why EPA is missing deadlines, and they don't offer any reason to rewrite the statute. Mark, are you still there?
I am still here. I just had a power blip.
Oh,
So
no.
it disappeared. Let me come back on video. Well, maybe I can't come back on video.
So
But
can I add a comment, Mark, while you're kind of troubleshooting there? So the scope issue is also really integrally tied to the question of what happens with preemption. And that's an issue that has been discussed at this event, I think, since its inception. Kind of what happens at that risk determination step. What does that mean for preemption if there's no unreasonable risk? And what does it mean at the very end, right? When you have a final risk management rule, what does that mean for preemption? So this question of what's in scope and what isn't in scope is ultimately going to flow through and inform what will be preempted in the states and at the local level at the final end. So stakeholders have not been aligned on that question of whether everything should be in scope for purposes of maximizing preemptive relief, or whether EPA should be managing the flow-through process in a way to be continually screening out lower risk scenarios, continually trying to focus its resources and time on the higher risk, the unreasonable risk scenarios, and its limited resources in risk management to address those. So I don't know that we need an extensive discussion of this. We probably should note for our attendees that we still do not have any courts that have had the opportunity to weigh in on what TSCA preemption looks like. So that's probably going to be in the bucket of maybe next year, right? Maybe we'll start to know the answer to that. But I did want to flag that because it is an important question of how the statute is implemented.
Could I ask a question, Karen?
Mm-hmm.
For that second set of stakeholders who would like to see sort of, I think you use the term maybe managing the throughput or managing the flow through, like would like to see scoping. How do they view preemption as working? If you exclude things from the scope at an early stage, what do they think?
Yeah,
What do they think gets preempted?
Right. The preemption is going to apply to things that were scoped in and were included in the body of the risk evaluation. So if EPA excludes from scope, a clean read of that is no preemptive relief will attach whatever was exempted from scope. So we still don't know the answer, though. Again, what would a court do with that? Does it have to be included in scope and fully go through the risk evaluation and get a risk determination? Kind of what does that mean? And it gets to the question of what level of granularity and clarity does EPA need to reach when it describes those conditions of use. So, and then you raised a great point, Tosh. If there's a kind of a late discovered use, let's call it, right, as we've seen come up sometimes in both the risk evaluation and the risk management steps, is that in scope? Is it not in scope? Kind of what does that look like, and what sort of coverage would it get at the back end? So those are all good questions. I'm looking forward to next year, and right, we'll see.
We'll see.
Yeah.
One quick question I have related to this topic was that, again, more as a practitioner, not an attorney, is kind of the definition. I know there's statutory regulatory bounds around scope that we're discussing. To me, that's part of what's in the scope. Another part is that within the clear domain of COU OES categories, sometimes things get scoped out because there's an initial screening assessment essentially that says there's really no predicate for there to be a potential concern here. And I'm not sure that we have good harmonized approach to those decisions because I've seen them change, de-scope or re-scoped and de-scoped. And it seems like get clearer, harmonized guidance on how that decision is made and what kinds of risk assessment tools or risk evaluation tools go into that tiered scoping seems like that would be helpful.
Mm-hmm. To your point, we know we're going to have a reopened risk evaluation framework rule proposed again. So this is a good opportunity for the agency to provide some additional guidance on processes and procedures that it will use to inform its decision making and provide transparency on how it reached those decisions. EPA is not required to repromulgate the prioritization rule, and I don't think they're even considering it. But they have put a lot of thought into what the prioritization process should look like. I guess for lack of a better term, pre-prioritization. So I hope the agency considers both of those pieces together. And like you said, Andy, some of those screening steps that it can take. My personal view, not speaking on behalf of my firm or my client, is the only way that EPA can meet those statutory deadlines in a meaningful, impactful way and get to targeted risk management is if it is thoughtful about scoping, it's thoughtful about the prioritization process, and it takes an approach that allows it, again, to kind of keep focusing all the way to the end. And risk management would be considerably more focused than it is at the moment. So some of EPA's more recent risk evaluations seem to be moving in that direction, where kind of a more curated list of conditions of use are assigned unreasonable risk. So there's a little clearer roadmap to what will happen in risk management.
So building on the issue of EPA's ability to do comprehensive risk evaluations with its available resources and anything close to the statutory time periods. Another issue that comes up is aggregate exposures, cumulative exposures. The statute directs EPA to describe whether aggregate exposures were considered and the basis for that consideration. So it's not a requirement. So far, EPA hasn't done much in the way of aggregate exposure assessment. There are clearly some scientific reasons why you would want to do aggregate, why you would want to do cumulative exposures. It hasn't done so. It's taken some baby steps, at least in the direction of doing cumulative exposure assessments for phthalates. But is the idea of the best risk evaluation in conflict with the practicalities and what should be the appropriate outcome? Rashmi, what's your thought here?
Yeah, thanks, Mark. I have a lot of thoughts. And I think I'll walk through kind of, what we consider the best scientific practices for what would result in the best risk evaluation. And I don't think that the incorporation of all of those methods has to be in conflict with, what is most efficient or what gets us to a risk conclusion fastest. You have to start out with systematic review. We know that EPA's approach to systematic review, which is the process of systematically evaluating the scientific evidence that then kind of underlies the science that is used to make risk determinations. We know that EPA's process is flawed. The SAC, EPA's own SAC, has highlighted in 2022 200 different recommendations for how EPA can improve its systematic review process. That includes publishing a protocol for how they're going to conduct the systematic review before they conduct the systematic review. That also includes adequately identifying all evidence streams. We've seen, for example, the phthalate risk evaluations for several of the phthalates, including DINP and DIDP. EPA left out epidemiologic evidence altogether. They did not consider toxicological evidence past 2019. These are all errors in their systematic review process. And we've highlighted this, these issues extensively in our comments. And, so has the SAC, as I mentioned previously. And, there are also issues in the way that EPA quantifies risk, especially in the way that they quantify non-cancer risk. They rely on this flawed margin of exposure or threshold approach, which essentially assumes a safe exposure level, below which there is no risk. And we know that there is a non-zero probability of risk across all exposure levels. There are best methods that have been released by groups like the World Health Organization, which we've applied those methodologies again extensively in public comments. We are putting together a manuscript. We had scientists as part of our group, as John mentioned to, as John alluded to in the previous session, go through, even using exposure levels of the ECHL. And we calculated, for example, for PCE, that workplace exposures that were acceptable led to a 1 in 200 risk for visual decrements and issues with memory function as a result of PCE exposure. And again, that's 5,000 times higher than the 1 in 1 million benchmark, which EPA typically uses to characterize cancer risk, and 500 times higher than even the higher end of that, 50 times higher than the higher end of that, which is the 1 in 10,000. So, by not using best available methods, we have found empirically that there are significant underestimations of risk. And with DCHP, we found a 1 in 20 risk for developing male reproductive harm in the general populations. This extends beyond workers. Then, of course, there's also the issue of characterizing exposures adequately. We've talked about the importance of characterizing high-end exposures, characterizing exposures to workers who are not wearing PPE. This also means characterizing exposures to people who are experiencing exposures to the same chemical from multiple routes and pathways. As John mentioned in the previous session, someone or a child who could be mouthing a toy, who could also be, living in a house that contains these materials and household dust. Potentially also someone who's working at a factory manufacturing this chemical and also handles a consumer product that contains this chemical and also lives in a home that contains, chemicals in the household dust. There's just so many kind of combinations of exposures that are routinely not evaluated in risk evaluations, and that leads to an underestimation of risk. And then, of course, there's this issue of taking it all together with a cumulative risk assessment. This would, of course, characterize exposures, aggregate exposures to a single chemical. This would also characterize exposures to other chemicals that, contribute to common adverse health outcomes to the chemical of interest. Also for which there are, evidence of co-exposures to those chemicals in the human population. And the cumulative risk assessment would also factor in different factors that increase an individual's susceptibility to harm from chemical exposure. So this could be underlying disease or experiencing psychosocial stress from poverty or racial injustice. Really taking all of these factors into account that provides a much more full picture of real-world risk estimates. Now, that's kind of just a very high-level summary of how the science could be improved in risk evaluations. And implementing those steps does not necessarily have to take an enormous amount of resources or time. We applied the World Health Organization methodology in-house. One scientist did these analyses for now over 14 chemicals. And that was done in the course of 6 months for one person, which is well within the time frame of conducting a risk evaluation. That is something that is well within reach of EPA to do kind of in the normal time frame for conducting risk assessment. In lieu of conducting a cumulative risk evaluation, you could adopt the use of uncertainty factors. Groups like California EPA and their Office of Environmental Health Hazard Assessment, or OEHA, has already adopted additional uncertainty factors to account for the increased susceptibility during early life. So this is something that we're seeing put into practice, by EPA, it's by California EPA. It's not, something that's uncommon or not justifiable scientifically. So I'll stop. And then, if you think about aggregate exposures in addition, that is really just, kind of adding a plus sign between exposure routes that EPA is already considering. So these are not drastic changes that the agency needs to make in terms of time and resources, but they are drastic in terms of actually considering the full risk cut. So
can I ask a question for the panel? That was extremely thoughtful and helpful, Rashmi. I have kind of a legal question as the follow-on though, right? So I know stakeholders have been thinking about cumulative exposure, whether there's a best available science issue or not. That's been discussion has been going on for years. But the term cumulative never appears once in the statute, that at least that I remember. So post Loper Bright, is this something where if a court were to take a look at that, it would say there's no express statutory authorization to even do a cumulative review? Maybe I probably should ask Tosh and Mark on that. But I think you teed that question up really well with your discussion.
Thanks, Karen. And yeah, I might kick that to Tosh. And I know Earth Justice has done an extensive evaluation of what legal provisions within TSCA actually do require EPA to consider cumulative risk.
And my view is that there's plenty of room in the statute for EPA in its discretion to do cumulative risk assessments.
Okay.
Yeah. One quick comment I would just make from the technical applications approach is, in the industrial hygiene community, as AIHA, we spent a lot of effort over the last 15 years on aggregating cumulative risk assessment methodologies, and we, use those, but a lot of times those will get fit into the risk management step, because it's really hard to do that cumulative cumulative and aggregate risk assessment for a specific COU or OES. You can do it for a population of workers or an industry, but it's harder to do it COU by COU because there's so many other variables. So I think that idea is really important, but I think that can easily fit into the risk management steps and we have a lot of tools, and Rashmi, you mentioned some of those. Changing the ECHOs to reflect more uncertainty about cumulative exposures, relative source contribution techniques, and other. But I just want to mention AIHA has resources. It really kind of falls under this banner of total worker health. So that's a term that folks might want to look into if they're not familiar.
So we are getting close to the end of our time. I think it's worth making a few comments about timing. The EPA, the first Trump EPA, spent 3.5 years plus doing 10 risk evaluations. The Biden administration reconsidered several of those risk evaluations and was able to come up with 2 final risk evaluations on the next 20 chemicals. There are others in progress. The second Trump administration has actually issued one final risk evaluation, which does show some differences from the draft risk evaluation that was issued under the Biden administration. But I think the Trump administration is likely to want to reconsider a number of the Biden draft risk evaluations or in progress risk evaluations. And in fact, in the case of 1,4-dioxane, has announced already that it plans to reconsider the Biden reconsidered risk evaluation for the first Trump risk evaluation for 1,4-dioxane. All of this is in the face of a consent decree that brought by actually 2 consent decrees relating to timing for risk evaluation. So it's going to be quite a challenge for EPA to meet those statutory deadlines, and which it's already missed, but the court ordered deadlines to deal with. We're still trying to clean up some of the first 10 chemicals. We've got 20 chemicals that are now all past due. The 6-month period for issuing final scope decisions for the next 5 chemicals has already passed. So I anticipate that with those considerations, plus what Tosh pointed out, the impact on agency resources from the current administration, I expect the risk evaluation process to slow down considerably, and that the agency will be asking the court for more time, at least in consideration of resource constraints. So the whole TSCA process, the whole TSCA pipeline, which ultimately ends in risk management and at court decisions, I think is going to turn from a gushing geyser more into a molasses pipeline, but that we'll have to see. And with that, I want to thank all of you for your very insightful comments. I think this has been a great panel, and thanks very much.
We hope you have enjoyed this rebroadcast of the TSCA Risk Evaluation Process Session from TSCA Reform 9 years later. The topics discussed are as timely today as they were in June. All Things Chemical is produced by Jackson Bierfeld of Bierfeld Audio, LLC. We'll be back again soon to further inform and entertain you about all things chemical. Bye-bye.